ಹಾಕಿದಿರಿ ಎಕ್ಸಿಬಿಟ್ D1 ಅಂತ.
D1,
ಅದಾದ್ಮೇಲಿಂದ ಒರಿಜಿನಲ್ ಪಾಸ್ಬುಕ್ ಹಾಕಿದಿರಿ, ಅದನ್ನ D3 ಅಂತ ತೋರಿಸಿದಿರಿ, ದುಡ್ಡೇ ಬಂದಿಲ್ಲ ಅಂತ ತೋರಿಸಿದಿರಿ ನೀವು.
No,
Is it sufficient?
no, one correction, my lordship. Illi, when the check is 58,9,003, my lordship.
I am not worried about any of
His
those things.
subsequent checks 58,904, 905, 908 has been honored on in the year 2009 itself.
I don't know why you did not honor. You should have issued the stop payment, no?
It was with
No, you should have stopped, no? ನಿಮ್ಗೆ ಗೊತ್ತಾಯ್ತಲ್ಲ, ಅವ್ರ ಗಂಡನ ಮೇಲೆ ಹಾಕ್ಬೇಕಾಗಿತ್ತು ಕರೆದು ಕೇಸಿ. ಯಾಕಲ್ಲೋ ಹಳೇದಕ್ಕೆ ಚೆಕ್ ಇಟ್ಕೊಂಡು ಮೋಸ ಮಾಡಿದ್ದೆ, ನೀನು ನಿನ್ನ ಹೆಂಡತಿನ ಜೈಲಿಗೆ ಕಳಿಸ್ತೀನಿ ಅಂತ.
In the year 2015 he died. Thereafter this has been happened, my lordship.
ಆಲ್ ರೈಟ್ ಸರ್, ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ ಕೇಸ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು. ನಿಮ್ ಗಂಡಂಗೆ ಕೊಟ್ಟಿದ್ದ ಚೆಕ್ ನ ದುರುಪಯೋಗ ಮಾಡಿದ್ಯಮ್ಮ ಅಂತ ಹಾಕ್ಲಿಲ್ವಲ್ಲ ನೀವು?
We have taken the presumption.
Yes, ಬರ್ಕೊಳ್ಳಿ. Hard. Shri Naeem Pasha, what's your name?
Mallikarjun DK.
Shri Mallikarjun for Shankar Reddy. First, accused to suffer an order of conviction in CC number 126 of 2018 for the offence punishable under section 138 of the Negotiable Instrument Act, confirmed in criminal appeal number 1064 of 2019 as preferred this revision petition. First, next para. Case in brief for disposal of the revision petition are as under. Next para. A check said to have been given by the accused towards the repayment of the debt that was borrowed by the accused on presentation came to be dishonored with an endorsement funds insufficient. First, legal notice was issued by the complainant to the accused, which has been returned with an endorsement, addressee refused. First, thereafterwards, complaint came to be filed. Learned judge took cognizance, secured the presence of accused, recorded the plea. First, accused pleaded not guilty, therefore trial was held. In order to prove the case of the complainant, complainant got examined herself as PW1 and placed on record 5 documents which are exhibited and marked as exhibit P1 to P5, comprising of original dishonored check, bank endorsement, copy of the legal notice, postal receipt and unserved postal cover with an endorsement, addressee refused. First, on closure of the evidence of the complainant, accused stepped into the witness box, examined himself as DW1 and placed on record notarized copy of the Aadhaar card, notarized copy of the passport and original bank passbook. First, next para. Accused statement as is contemplated under section 313 CRPC was also recorded, wherein accused has denied the incriminatory circumstances. Subsequently, the learned trial magistrate heard the parties and by order dated 9/4/2019 convicted the accused for the offence punishable under section 138 of the Negotiable Instrument Act and imposed the fine of rupees 5,10,000 as against the check amount of rupees 5 lakhs and ordered 5 lakhs to be paid as compensation and 10,000 rupees towards the defraying expenses of the state. Next para. Being aggrieved by the same, accused preferred an appeal before the district court in criminal appeal number 1064 of 2019. First, learned judge in the first appellate court, after securing the records and hearing the parties by order dated 7 January 2021, rejected the appeal filed by the accused and confirmed the order of conviction and sentence. Next para. Being further aggrieved by the same, accused is before this court in this revision. Shri Naeem Pasha, learned counsel for the revision petitioner, strenuously contended by reiterating the grounds set in the revision petition that the check that has been issued in favor of the husband of the complainant has been misused by her after the death of her husband, and a false case has been foisted against the accused. First, he also pointed out that the check number that has been number of the exhibit P1 would go is to be looked into, and subsequent checks issued by the accused has been honored to and to evidence the same, exhibit D3 passbook has been produced. The copy of the passbook has been produced and marked by the defendant, which shows that marked by the accused, which shows that accused was never intending to dishonor the check if it has been issued by him for the legally recoverable debt, but the but in the case on hand, it has been dishonored as it was not meant to be given for legally recoverable debt, and which shows that the check has been misused. First, next para. He further pointed out that the accused, the financial capacity of the complainant is not established in as much as she has specifically stated that she received the LIC bond amount and other financial aspects that will be subsequent to the date of issuing the check, and therefore, it was, the check has been misused, which has been ignored by both the courts and sought for allowing the revision petition. Per contra, next para, per contra, learned counsel for the respondent complainant supports the impugned judgments. Having heard the, next para, having heard the parties in detail, this court perused the matter law on record meticulously. Next para, on such perusal of the matter law on record, issuance of exhibit P1 and signature found therein that of the accused is not in dispute. According to the accused, the check was actually given to the husband of the complainant by name Devraj, who died in the year 2015. First, in other words, it is the defense of the accused that the check that was given to the husband of the complainant has been misused by her, taking advantage of death of her husband. First, if that is so, at least after the accused put in appearance before the learned trial magistrate, some positive action should have been taken by him in prosecuting the complainant for misuse of the check, or at least issuing a legal notice narrating these aspects of the matter. No such positive action has been taken by the accused in this regard. First, when once the check is in the hands of the complainant and the signature therein is not disputed by the accused, and the bank has returned the check with an endorsement funds insufficient and legal notice having been refused by the accused, the presumption as is available to the complainant under section 139 of the Negotiable Instrument Act comes into play, and the same has been invoked by the learned trial magistrate in favor of the complainant in the trial. First, next para. No doubt the said presumption is a rebuttable presumption. First, in order to rebut the same, accused has stepped into the witness box and examined himself as DW1 and placed on record 3 documents. First, among the 3 documents, one is a notarized copy of the Aadhaar card, second is the passport, and third one is the bank passbook. First, the oral and documentary evidence placed on record by the accused would only go to show that, that the complainant has tried to misuse the check, and there was no, and such evidence was not sufficient to rebut the presumption available to the complainant under the statute. First, next para. In view of the above factual aspects of the matter, the learned trial magistrate was justified in convicting the accused and passing the sentence as aforesaid. First, learned judge, next para. Learned judge in the first appellate court on reappreciation of the matter law on record did not find any good grounds to interfere with the order of the learned trial magistrate and accordingly dismissed the appeal. First, this court, that too in the revisional jurisdiction, does not find any good grounds to interfere with the order of the conviction. First, so far as the sentence is concerned, learned trial judge has imposed rupees 10,000 to be paid as expenses, defraying expenses to the state, which is impermissible, having regard to the fact that the list is privy to the parties and no state machinery is involved. Accordingly, same needs to be set aside. Hence, following order, criminal revision petition allowed in part while maintaining the conviction of the accused for the offence punishable under section 138 of the Negotiable Instrument Act, imposition of the fine of rupees 5,10,000 is reduced to 5 lakh, and the entire 5 lakh is to be paid as compensation to the complainant, failing which the accused shall undergo imprisonment for a period of 1 year. First, next para. Imposing the fine of rupees 10,000 to the state towards the defraying expenses is hereby set aside. Time is granted for the accused to pay the balance amount of the fine till 30th June.
Number 33, Balaji Raghunathan.
Balaji? Yes, sir.
Petitioner, my lord.
Yes, sir.
My lord, this is a case where this complainant, original complainant, is a totally unknown lady to this accused, my lord.
Yes, sir.
That is the main contention. Our case itself is based on that.
Yes, sir.
The entire, according to her own complaint,
Hmm.
she has lent 6,80,000.
Correct.
She herself says, I have reduced it in a panchayat to 4 lakhs.
Correct.
Ultimately, he is called to the police station with respect to a transaction with one Sumati.
Yes.
Sumati also was called to the station. There, this accused was asked to give check what he is liable to pay to Sumati. Blank checks were given. And those checks were misused.
Yes.
My humble submission, my lord, Repeatedly, I have been asking, their case is that it is from the retirement benefit of her husband, the money was paid. They
Yes,
have not submitted before the honorable court either the bank statement, even I have filed an application, it was rejected, I filed a criminal revision petition before the honorable sessions court. Honorable sessions court observed that if it is, they are not proving by producing the necessary document, let it be, adverse presumption may be presumed against them. Now, my humble submission, that particular order was also placed before the honorable trial court. That was not considered. my lord.
anything else?
My lord, here, this Sumati, she was called to the station. There was a panchayat, the document, panchayat document, that is marked as exhibit D1 and D2.
Yes,
That is also marked in the case
yes,
to show that this money was paid for Sumati, whom he was liable to pay only 1 lakh.
yes.
This check, blank checks were misused
Hmm,
by this complainant.
hmm,
She filled up for 4 lakhs,
hmm.
2 lakhs each,
Hmm.
same dates, and misused. my lord.
Over? Anything else?
That's the main ground, my lord.
That's
Consideration
okay,
is not,
anything else?
consideration not proved, my lord.
Yes. Kindly read 118 and 139. You are hearing the previous case,
Yes, my lord.
you have heard the dictation also,
Yes, my lord.
you know the position. Any criminal complaint filed by your client against Rajeshwari?
The
or
check itself
Sumati?
was given in police station, the same police station.
Sir,
Check was.
I am
taken-
only asking you whether you have taken any action.
No, my lord.
Why?
No, this, because this.
Why?
No, this complainant.
No, if there is a misuse, why do you keep quiet?
No, misuse means it was, check itself was given in the station.
I don't know, sir. You should have gone to the magistrate, no? File a complaint that the police are also involved in extracting a check. Make the police inspector also an accused.
Got our evidence, my lord.
No, you should make a complaint, no?
That he has not done.
Then what to do?
But my humble submission.
No, your submission is okay, sir. 2 courts have held you as convict.
Yes, my lord.
I am in revision.
No, no.
See, tell me, simple point, have you taken any action?
My only thing.
Any
was I
action?
filed an application.
Any action is the question, positive